Okay, I think we're going to go ahead and get started as folks are continuing to join. Thank you all for joining us for today's discussion on using restorative justice in the most serious cases. My name is Rachel Marshall. I'm the Executive Director of the Institute for Innovation and Prosecution at John Jay College. The IIP provides a national platform to bring together prosecutors, policy experts, and the communities they serve to promote data-driven strategies, cutting-edge scholarship, and innovative thinking. The IIP champions criminal justice reform policies that advance community-centered standards of safety, fairness, and dignity, and we are so delighted to be here today hosting this event with our esteemed guests. I am very excited about today's discussion because, as we all know, restorative justice is very often misunderstood, and as a result, it's really often underutilized by prosecutors. Many prosecutors are wary of using restorative justice approaches in the most serious cases in particular, even though those are precisely the kinds of cases where it can actually be most impactful, as we'll hear more about today. So I'm really excited to dive into this complex topic with our incredible panelists, who I'm going to briefly introduce, but we will be putting all of their full bios in the chat, so feel free to read more about each of their experiences and accomplishments. But I will briefly introduce them before we get started. Satana DeBerry serves as the elected district attorney for Durham County. As district attorney, she has prioritized the prosecution of serious offenses, implemented policies to reduce unnecessary pretrial incarceration and court involvement, and has worked to improve trust and equity in the courts. Throughout DA DeBerry's career, she has worked to dismantle systems that restrict the lives of poor people, families, communities of color, and other marginalized and underrepresented groups. DA DeBerry has also increased the use of mediation for greater victim-led and victim-centered accountability and expanded the use of restorative justice to address violent crime. Dr. Alyssa Ackerman is Associate Professor and Criminal Justice Program Coordinator at California State University Fullerton and is the co-founder and owner of the Ampersand's Restorative Justice Program. She is a pracademic and survivor scholar in that she incorporates her academic training, practitioner, and personal experiences with sexual violence in her work. She holds a PhD in criminal justice from the City University of New York. Alyssa's dedicated her career to understanding everything she can about sexual offending, the impacts of sexual victimization, and restorative options for those who are impacted by sexual harm. After participating in a life-changing vicarious restorative justice as a survivor, she began building and facilitating processes for others who sought restorative options as part of their own healing. And finally, Seema Gajwani is Special Counsel for Juvenile Justice Reform and Chief of the Restorative Justice Program section at the DC Office of the Attorney General. Prior to this position, she ran the Criminal Justice Program at the Public Welfare Foundation in Washington, D.C., funding efforts to improve criminal and juvenile justice systems across the country with a focus on pretrial detention reform and prosecutorial culture change. Seema started her career as a trial attorney at the DC Public Defender Service, representing juvenile and adult defendants for 6 years. She was chosen as a 2019 Obama Fellow for her work on restorative justice and was awarded the ABA's 2022 Crime Victim Attorney Award. Welcome to all three of our very impressive panelists. We're so honored to have you here. I am going to dive into this discussion because we have so much to cover and you all have so much expertise to offer. But I wanted to let everyone in the audience know we will be taking questions at the end, so feel free to put them in the chat throughout our conversation and we will be sure to get to them at the end of today's program. So let's get started by sort of setting the stage a little bit. And I'm going to turn to you, Professor Ackerman, to set the stage. Can you kind of give us an overview of what is restorative justice and what are the origins of it? Where does it come from as a theory?
Sure. So at Ampersand's, we define restorative justice as a human-centered approach to repairing and preventing harm. But Howard Zehr, who is sort of known as the father of Western restorative justice, says that restorative justice is a process that involves, to the extent possible, those who have a stake in a specific offense, and to collectively identify and address harms, needs, and obligations in order to heal and put things as right as possible. But really, the principles of restorative justice have been used for thousands of years in indigenous cultures and traditions, both here on the North American continent and around the world. Collectively, restorative frameworks took hold here in the United States within the criminal legal, youth justice, and community spaces around the 1970s. but really there was little honoring of the indigenous frameworks and wisdom from which we took. And we could actually go a step further and name that indigenous peoples were sort of forced into Western systems of punitive punishment and lost their ability to really practice in circle and in dialogue. And so really, we have an obligation to name that the practices that we are using really do stem from indigenous wisdom. So while we are not practicing indigenous practice, we are drawing on that wisdom in the restorative practices that we are using today. So all of that is to say that restorative justice is a framework designed around a series of principles. And namely, what that means is that we see the humanity in all of the people that we are working with, and that we seek to do no additional harm to the parties involved, while holding the party who has caused harm accountable for their behavior.
Great, and we're going to dive into what that looks like practically in a couple of moments. But before getting there, D.A. DeBerry, I wanted to ask you about your use of restorative justice, which is pretty rare for prosecutors to use, especially in the South. Can you explain to us why you chose to use restorative justice as an approach in your office, particularly as a method of combating violent and serious crimes?
Sure. So it was interesting to listen to how Professor Ackerman described restorative justice, because often in a punitive system, we think of winners and losers. And really in the criminal legal system, we're all losers. And restorative practice in our office has become a way to acknowledge that, there's been sometimes deep harm done, that even when a defendant has been held accountable, there's still something left that needs to be said, or there's still something left, especially when you yourself have been a victim, and you just want to understand why. And so what we have tried to do in our office is look for green flags that make restorative justice available in any case in which a victim and a defendant agree that it is appropriate. I know in a lot of prosecutors' offices, it is used for low-level things, but we want to use it in a way that acknowledges that most victims of crime and defendants knew each other beforehand. And sorry for if you hear the train in the background. The train is going by my window. But that acknowledges that people knew each other beforehand, that they have had harm against them, and that they often just, more so than they want punishment, they want to understand why it happened and why it happened to them.
So I want to follow up on one thing you said, DA. You mentioned that a lot of times it's used in sort of less serious cases, or restorative justice isn't used in the most serious cases. And, I like to think of it sometimes as prosecutors might use that approach in what I call the low-hanging fruit, the cases that maybe shouldn't even be prosecuted, maybe should go through other sorts of approaches generally. And they're not using it in the cases that are very serious, or where it may be able to have the biggest impact, or that may be, frankly, harder to message, or maybe of greater concern to the public who don't always understand restorative justice approaches. So what is your office's approach to which cases you will consider? You said you look for green flags. What does that look like when you decide which cases you should use restorative justice for?
So we don't have a specific policy that says you can or cannot use restorative justice in a case. What we tend to do in our case, well, let me take a step back. You talked about kind of low-hanging fruit, and I think that's true. I think most prosecutors would tell you, if you had, say, a school fight between two teenagers, that they might use restorative justice in that case. Maybe if they had an incident of property damage in a neighborhood, or where it was neighbor versus neighbor, or something like that, those are the type of things that they would feel very comfortable allowing a restorative justice process to happen. And I think that also misunderstands restorative justice, because it substitutes restorative justice for the criminal legal process. And that's not really what we're trying to do. And when you think about it like that, it makes it a little, it makes it clearer on how you can use it in more serious cases. We look for situations in which the victims are kind of constantly asking us questions about, well, did he say why he did it? Or did he mention this? Or, they want more information than what just happened, right? They know what happened. They want really kind of deep information about why it happened. So we're often looking for that type of green flag, what we call green flags in a case, to see if that is something that we approach. And so it often goes alongside criminal accountability. And I know later we're going to talk about maybe a case in specific, but we don't substitute it for accountability. Like you said, if it's low-hanging fruit and it's something that shouldn't be prosecuted, then it's not prosecuted. If it's something that needs to be prosecuted, but there are still lots and lots of questions about what's going to happen when that person, if that person is going to prison, when they come back, what's going to happen. Those are the type of things that lead us to really think that restorative justice is appropriate in that case.
Team, I want to bring you in to talk about the ways in which prosecutors have traditionally utilized restorative justice and what you see in your work as a benefit of using restorative justice approaches, is along with, what are some reasons why it's not being used in a more widespread way? What are some reasons why it's not being used more frequently in all sorts of cases in the way that DA DeBerry has just spoken about?
I think, well, first of all, thank you for having me. We started a restorative justice program within the office, and I work for the Office of the Attorney General, which is the prosecutor of all youth crime in the District of Columbia. We started under Attorney General Carl Racine, and our work has continued under the new Attorney General, Brian Schwab. When we started, there was a lot of resistance among prosecutors, among court personnel, among probation, really all stakeholders, because I think it's restorative justice is seen as something that is, as DA DeBerry said, restorative justice, a core component of this, and Professor Ackerman, is accountability. But a lot of prosecutors and others in the system don't see it as accountability. And it's different, change is hard, I think. And what we're used to as court officials and players in this system is we're used to this adversarial system. And I think the adversarial system is actually, over hundreds of years has been like well tweaked and tuned for trial, for cases where somebody wants to contest their guilt, challenge the government's evidence, exercise their constitutional right. And so in those situations, what the court system and our whole process, the adversarial process, does is it distills the event to, elements of the crime. It takes the emotions of the victim out of the situation. It silences the defendant or respondent so that they are protected by lawyers. And people who have no idea about what happened based on their own personal experience are the ones having the discussion about what happened and what should happen going forward. And in many ways, that makes sense for trial, where we want to protect the rights of an accused, where you have the behemoth of the state bringing all of its power against a person. But what it's terrible for, the adversarial system, what it's terrible for is situations where somebody wants to take responsibility for their behavior. And in 95% of cases in courts across the country, cases end up with plea deals. So we've used this adversarial system that is well honed for one thing, and it's being used in this other way for cases that end in pleas. And it's a terrible system for that. And I think when prosecutors and others realize that the things that we're trying to get out of the system, which is we want people to change their behavior, right? We want somebody who's accused of a crime, who takes responsibility for the crime, to change their behavior. We're not getting that out of our current system because our recidivism rates are really high. We want healing and closure for victims. Well, victims say that the second worst experience that they've had after being victimized is their experience in the criminal justice system. And we're not doing it in a way that is equitable and provides dignity to all parties. And so I think, I guess I would say that the reason that prosecutors and others continue to work in the system that is not really working, like DA DeBerry said, everyone comes out a loser in these cases, is because it's what we know. But I think if we take a critical eye to what we're getting out of this system and out of these cases, in large part, what we'll find is there has to be a better way. And sometimes restorative justice is.
Thank you. I want to kind of turn to some of the implementation around what restorative justice actually looks like. And I'm going to start with you, Alyssa, even though you primarily use restorative justice approaches outside of the traditional legal system. And I was hoping you could give us an overview of how you use restorative justice approaches, how the role of a facilitator, the length of time, and kind of just give us a little bit more of a concrete understanding of what it looks like in your work.
You'd think after years on Zoom that I would remember to take myself off mute. So as I said, in the opening question, the way that I think about restorative justice is around doing no additional harm, honoring the humanity of all people, and really, in my practice, making sure that the process is survivor driven, right? So making sure that I'm listening to the needs of those who have experienced harm. What are their needs? What are their wants? What are their goals for the process? But it's very, very nuanced because, oftentimes when survivors come to this process, they think, well, you're on my side. But facilitators oversee the process, right? They're not taking a side. Their role is to be stewards of the process. They build relationships with all of the parties that are involved, right? And that can be really hard for survivors sometimes when they realize, oh, you're building a relationship with the person who harmed me. Well, in order to get those needs, wants, and goals met, in order to help somebody change their behavior, you also have to build that relationship too, right? So you're not taking anybody's side. Your side is the process, right? And yet you have to remain survivor driven. Like, how do you get these needs, wants, and goals met? Well, also, making sure that you're meeting the needs of the person who perpetrated the harm too. So honoring the humanity of all people, making sure that you are survivor driven, but always coming back to the questions, what harm was caused? What can be done to make things right? What can be done to rebuild trust? And sticking to the values of restorative justice. So remaining compassionate, remaining trauma informed, building connection, remaining honest, both in the way that you respond, and making sure that, the people that are in the process are sticking to these values too, right? We want transparency, we want honesty, we want vulnerability. And that's really, really hard to do. So all of that then leads to what the process actually looks like. So the process that I use is a 5-stage process. The first is first contact. So typically survivors come to me and say, I am interested in this process. Will you help me? And so in that process, we are also looking for green flags, as DA DeBerry talks about. And we're also looking for red flags. There are some people who are not ready for a process like this. And so, first contact, we are explaining what the process is. We talk about the limits of restorative justice, what can be accomplished in a process like this, what cannot be accomplished in a process like this. And if somebody is looking for punitive measures, this isn't the process for them. The second stage is a full intake, a full assessment. So we're looking at things like depression, anxiety, PTSD. We do a full clinical assessment because we want to ensure that the people who are participating in the process like this are resourced. And if their mental health is in a place that they cannot participate in a process like this, we ensure that we get them resourced so that at some point they can be. But, the cases that I take, as we'll talk about later, they are all sexual harm cases. And so the cases that I'm seeing are fundamentally different, I think. So we really want to make sure that people are resourced, that they have a therapist, that they are ready to participate. Then we move into pre-conference work, which is where I think all the magic happens. And that's with both parties, with the survivor and with the person who perpetrated harm. After we move through all of the pre-conference work, then we get to the conference process, whether that's a one-on-one process or a circle process. And then we move to a debriefing process. So I check in at 3 days after the process, and then I do a 1 month follow-up as well. Processes can take, 1 month to 3 months. They can also take up to a year. One of the things that I think really is important to know about restorative justice is plan for it to take longer than you expect it to take. Because these processes are very, very deliberate. And we want to make sure that we are doing no additional harm to people. And sometimes there are pauses when these processes happen because we want to remain trauma informed.
Thank you, Professor. Seema, I want to ask you about your case process selection in your office. How is it that cases are assessed to be eligible for restorative justice? And I know that your office is also using a randomized controlled trial, and I'm hoping you can touch upon that as well.
Sure. So when a case comes in and is assigned to a restorative justice facilitator, what the facilitator does is first reach out to the prosecutor of the case and sit down and talk about the case, and they work together to discuss any contact with the person who's been harmed or the victim of the case and any other folks involved. Then the prosecutor will kind of let the facilitator know that it's okay to reach out to the victim of the crime. At the same time, the facilitator is reaching out to the defense attorney, the person who represents the person who's charged, and asking for permission to speak directly with the person who's been harmed. With the person accused of the crime. In our cases, and almost all of our cases, not all of them, but almost all of our cases, these are minors. And so we'll also get permission from a parent or guardian before we speak directly with the young person. But what our facilitator is looking for when they speak to the victim is, as Professor Ackerman said, what are they interested in? What are they looking for? We always start out with just checking in. How are you doing? How are you feeling? What's changed in your life? What do you wish could happen? What would make you feel like justice has been served? What would make you feel better? Over time, our prosecutors have learned to ask a lot of these questions also of victims of crime, which is phenomenal. And one of the things we really wanted to see. And so that's why the facilitator and the prosecutor will discuss this and get a sense of where the survivor or the victim wants to go. And we defer to the victim of the crime about what they're interested in. If they're interested in meeting with the person, how they're interested in meeting with the person, if so, in what context, where would they feel most comfortable, etc. With the young person, when we talk to the typically young person who's been charged with the offense, our facilitators are explaining the restorative process, explaining how this is in many ways an alternative to traditional prosecution, the benefits of successfully completing the process. But then, importantly, our facilitators say, I need you to tell me what happened from the beginning with all of the detail that you can. And that's because we need to make sure that the young person is really willing and able to take full responsibility for what they did. Back when we first started, sometimes we'd have a parent saying, yes, they'll absolutely do this. They absolutely want to apologize. And you talk to the young person, they're like, yes, I'll say sorry. I'm happy to say sorry. I want the benefit of this plea offer that includes restorative justice. And then later, when we've already gotten the victim on board, when they've said they want to move forward and we've told them this is going to be a process, and you say, what did you do to the young person? They may be like, well, I'll apologize that this person got hurt, but it wasn't me, or I didn't mean it, or they did something to, trigger it or something in a way that's victim blaming. And so it's really important for us, for our facilitators, to check to make sure at the beginning that the person is truly willing and able to take full responsibility. And so that's how we assess a case, and where on both sides you have folks who are interested in resolution then we move forward. When we first started doing restorative justice at our office, we had prosecutors send us cases that they felt comfortable with, and we did a lot of training with prosecutors. We would sit and talk with victims with them sometimes. And typically, as DA DeBerry mentioned, they would send us low-level cases. We were very careful about net widening, so we would not take any case that would otherwise be dismissed, and we had systems in place for that. But over time, as prosecutors built trust with our facilitators, saw outcomes of restorative justice cases, they started sending us more and more serious offenses. And we've now been doing this for almost 7 years. We've had hundreds of cases go through successful conferences. And a couple of years ago, we decided to evaluate our program, and we started a randomized control trial. And what that requires is that the young people who are charged with offenses, in this case, serious offenses, their cases are randomized, whether they're offered restorative justice or not. So in the context of this evaluation, we now use a randomizer and a data specialist to send us which cases are in the control group and which cases are in the treatment group, since we don't have the manpower to take all of the cases anyway. So this is a random assignment of cases. And so at this moment, we don't have a discretionary prosecutorial role.
DA DeBerry, you talked a little bit about your office's approach to restorative justice cases. What training does your office provide to staff in terms of restorative justice and ensuring that line prosecutors are thinking about restorative justice and looking to identify those green flags, as you said?
I guess I did the same thing with unmuting myself. So we have had a senior prosecutor in our office who has been the point person for our restorative practice. She has now ascended to the bench. And so I'll just take a side note to say to prosecutors, often people are afraid that if they participate in this process, it'll come back to haunt them. It will impact their career. It certainly has not. She has been very successful after having trained all of us and worked on cases. So take that however you will. But we now have another senior lawyer in our office who has agreed to take that on. And they coordinate training. We have a community partner, Restorative Justice Durham, that works around training community volunteers to participate in this process. And they work with us to develop training for lawyers in our office. And so we do occasional training inside the office. And then if an ADA feels like they have a case that might work through the process, they then come to that senior ADA and say, hey, I think I have a case that might work. And they start to work together to pull it together. So pretty much it's a team effort in how we train and go through the process.
So I want to stick with you for a second, DA DeBerry, because you've used restorative justice in very serious cases, including a high-profile homicide case that was recently profiled in The Guardian. And hopefully we can put that in the chat, that piece, if folks haven't read it. And that was a case involving Donald Fields Jr., who was charged with murdering his father, and your office used restorative justice. I'm hoping you could tell us about that case, tell us about how your office approached it and how that process went.
Yeah, and I would really encourage people not just to read the Guardian piece, which is an outstanding piece of journalism, I think, but also to listen to the accompanying podcast, because in the podcast you will hear Alex Fields, who is the brother of the victim in this case. You will actually hear his actual voice. I mean, his voice does come through on the page, but to hear him actually describe it himself is very powerful. So I'd encourage people after this to go read that and listen to the podcast. So briefly, this case involved a victim, Donald Fields Sr., who was killed by his son, Donald Fields Jr., in an argument over, I think in the article it says the placement of a television set in their home, but it was about Donald Fields Jr. was playing a video game with his cousin, and his father wanted them to stop and move the TV out of the room. And they got into an argument, and Donald Field Jr. ended up stabbing his father multiple times, and his father bled to death. And this is, it's horrible that was a horrible crime for many reasons. Not just that their fight escalated into physical violence, but that it was father and son. And then Donald Fields Jr. further exacerbated the situation by running from the house. And they were living with Donald Fields Sr.'s mother, Donald Fields Jr.'s grandmother, who was confined to her bed, was very, very ill, and Donald Fields Sr. was her caretaker. And so she was left there by herself without her caretaker for several hours. Donald Fields Jr. later that evening, saw on television that his father had died and that they were looking for him. And he called 911 and turned himself in, waited, sat down on the side of the road, waited for the police to come and take him into custody. And so, as you can imagine, Donald Fields Sr. was one of many children. It was a very large family. And as you can imagine, it was one of the worst days of that family's life. They were a big family. They were, the kind of family where they don't really have outside friends because they're all each other's best friends, and they go to church together and they socialize together. And that particular day when they heard that their brother had been murdered by their nephew, they were all in church. And so it just got worse and worse and worse the more you learn about the story. And Donald Fields Jr. was arrested, and over time, the case was working its way as any murder case would work its way through this office. And at some point, Alex Fields, who is part-time minister, started to think about his own vocation, and that he was every Sunday standing in the pulpit and preaching his Christian values and forgiveness. And he started to think about his nephew, sitting alone in the Durham County Jail. And at that point, it had been years since anybody had even talked to his nephew. Now, remember, they're super close. And so he's had no visits from anybody. He's not talked to anybody. And Alex started to feel, as we say here in the South, some kind of way about that. And so he started to think how he would feel if he could not talk to his family ever again, if he had been ostracized. And so he started to make some entreaties to the ADA in the case, Kendra Montgomery Bland, about speaking with his nephew. And for Kendra, who was at that time our restorative justice lead, that triggered for her those green flags that we talked about. And she began to talk to Alex about the opportunity for restorative justice in this case. She reached out to our community partners and reached out to Don Jr.'s attorney. And it took a while for Don Jr. to get on board, but eventually he got on board. And RJ, we stayed our process. And that was, I think, the most important piece for our office, is that we said, okay, we are willing now to not proceed on this case any further until we see how this process goes. And RJ Durham put together a team for the Fields family, as well as a team for Don Jr. And, kind of in the interest of time, I will tell you that it took, I don't know how many people, it was like 100 people in our community who participated in this process, including the investigator who arrested Don Jr. And investigated and charged the case. And we were, I guess, lucky that the pandemic happened, because that also helped slow down the process. And Don Jr. began participating in the restorative process on his side. Professor Ackerman will be happy to hear that it included a mental health assessment and regular meetings for him with a therapist. And the Fields family began a restorative process on their side. And over time, those two things came together. And the Fields family created a repair agreement that Don Jr. signed, and that was eventually presented to our office. Now, by this point, Don Jr. had served, had spent about 6 years pretrial in detention, and which under our statutory framework was about the amount of time that he would have gotten. He'd not been in trouble before. He had no record for a voluntary manslaughter plea. And so what our office offered was voluntary manslaughter in exchange for him following the repair agreement, which was substantial. And that repair agreement would be court supervised, and there'd be regular check-ins. He'd have to do certain things to be released from detention, and then he'd have to do some other things. And the court would supervise all of those things. And so after about a year of court supervision and Donald doing everything that he was asked to do, the court entered the plea, and he was released from detention and has moved into a halfway house kind of place, a supportive housing environment that one of the people who was the coordinator for the team that worked with the Fields family is one of our community partners who works with us she works with us as the liaison to the families of murder victims. And so she's never met a defendant that she felt that she would want to do much for. Let's put it that way. She's a great woman. She's a Christian pastor. She has a lot of love and empathy in her heart, and a lot of her love and empathy she gives to the families of murder victims. And she herself used her own contacts to find supportive housing for Don Jr. That's just how transformational this process was for her and for the people who were involved. And so Don Jr. has now been, there are members of the family who didn't participate in the process. There are members of the family who did. For the members of the family who did, they have really reconciled themselves with Don and provided him with support and a way back home, a way to become part of that family. And I skipped really an important part. One of the things that really helped the family decide to participate in this process was in the process of having being evaluated for his competency. There were Don Jr. disclosed some things in that assessment that he gave his attorney permission to share with the family. And in the report, we learned that Donald Sr. had really been physically abusing Don Jr. most of his life. That he loved his father, but his father was regularly beating him. So this incident over the video game was just a moment in which Don Jr. had snapped, but it was not an uncommon incident. And Alex really felt that because he later disclosed to us that he had to break up a physical altercation between Don Sr. and Don Jr. Like he had himself witnessed that violence. And for the family at that point, they were like, oh my God, what did we participate? What part did we play in how this turned out? And that was something they had to work through in their restorative process as well. And so I'm not doing it justice because we have so little time, but I really would encourage you all to read the article and listen to the podcast, because it is a powerful story of forgiveness and redemption and accountability, right? Because Don Jr., who I have still not yet heard him say a single word. He's not spoken in court, but he's spoken to his family. He's spoken to his, obviously to his attorney and his team. But he has been described by almost anybody who knew him as one of the meekest people they have ever met, and a very closed off person. So for him to be vulnerable enough to disclose what had been happening to him, to the people who were most harmed by that, was really powerful. And for them to be back in community with each other, is something to see.
Yeah, and we put a link to the podcast as well in the chat. And thank you, D.A. DeBerry, for sharing that really powerful story. And again, I encourage folks to read more about it. We've just been talking about a homicide case in restorative justice. I want to talk about sexual violence a little bit. And Professor Ackerman, we often see that in many areas of the law and in sentencing reforms, there's often carve-outs for sex crimes in particular. And you have done such extensive work on using restorative justice in cases of sexual harm. I'm wondering if you could talk a little bit about why it's so critical in particularly those kinds of cases. And given your own experience as a survivor and your experience working with survivors, what do victims of violent and particularly sexual crimes want to see, and how can restorative justice help them in that?
Thank you for that question. I'm going to start with the second part of the question. So many survivors of sexual harm talk about the need to have a voice, to have some choice and voice in the process, especially for those survivors who do come forward to law enforcement. They want collaboration in the criminal legal process. Survivors have questions that they want answers to, right? D.A. DeBerry was talking about, right? The green flag cases are the ones where survivors are asking these questions over and over and over again. So they have questions that they want answers to. They want to be vindicated. They want to be believed. Right? There's this great piece out of the UK, I believe, that talks about kaleidoscope justice. And it's this idea that survivors' needs change, right? If you look into a kaleidoscope, the colors of the kaleidoscope change. Well, survivors' needs change too. And the criminal legal system is not always adept at moving with survivors' needs. It's not designed to, right? That was never the purpose of the criminal legal system, to move along with survivors' needs. And so for that reason, and for many other reasons, survivors of sexual violence don't often trust the criminal legal process, right? It doesn't meet their needs. So the vast majority of survivors will never report to law enforcement. And this is particularly true for those in communities where there is a fundamental mistrust of law enforcement and the criminal legal system. And when it comes to sexual harm, there's an entire additional layer of invisible punishment on top of prison sentences and probation. And so we know that most people who experience sexual harm are harmed by those who they know and who they care about and who they love. And many of us do not want to see those that we love punished with long sentences or a lifetime on the sex offense registry. And we also know that we may experience backlash or blame for having put somebody there. And so what I've learned in my RJ work is that healing from intimate harm requires connection. And it is often connection to the people who have harmed us. And like D.A. DeBerry was talking about in this case, It is connection to our family. It is connection to our community. It is connection to our friends. And when we experience this kind of harm, we lose connection to ourselves first and to those around us, right? And so to heal from that, we need that connection. So helping those who have caused harm to understand both the short and the long-term impacts of their behavior, helping to address root causes, and providing accountability partners really goes a long way in ensuring that people don't behave that way again. And that's really helpful for survivors, and for survivors to hear that from the person who harmed them. Like, I understand the impact of what I've done to you. These are the steps that I am agreeing to take to ensure I don't behave this way again. I'm going to abide by this agreement. Okay? And I am profoundly sorry for the harm that I've caused to you. That is so healing. Now, the work that I'm doing, as I said, I'm operating outside of the criminal legal system, mostly for survivors who do not want contact with the system, and mostly for survivors where the statute of limitation has passed. So these are cases, they are, many, many, many years after the process, or after the case has happened. But I can absolutely see these cases happening within a prosecutor's office. For people who do come forward to law enforcement, who still want answers to their questions and the accountability that happens through a criminal legal process.
Rachel, can I jump in and say a couple things in response to that? I think Professor Ackerman has made, some really good points. One, to the point that she, that this will work well in the prosecutor's office. There's also sometimes things that just don't reach prosecution. We don't have enough evidence. We can't move forward for whatever reason. That doesn't mean that people don't still want answers and they don't still want some type of engagement. I did a panel on restorative justice at North Carolina Central Law School with our sheriff and our police chief. And during that session, a public session, our police chief disclosed that she had been sexually assaulted in college and had never been able to come to terms with her. And right there on the spot, the RJ Durham people were like, hey, we can provide a process for you. If you are interested, we can provide a process where there's a stand-in for the perpetrator and that we can help move past this. So that was a super powerful moment, and a way in which we see how it acts in community to help restore connection in the way Professor Ackerman talked about. And then to even take a little bit more of a step back and say, back to what Seema was talking about earlier about what the adversarial system is. Like, you hear prosecutors a lot talk about, oh, I do this for the victims and I do that for the victims. That's actually not what our job is. Like, we represent the people of our jurisdiction, right? And we are prosecuting a crime against the people, against the state, against the government, right? We've created a social contract with each other that is our statutory laws. And when you break those statutory criminal laws, there must be accountability under a certain framework that is also set up by our statutory criminal laws. That is not a direct one-on-one situation, even though you hear people talk about it all the time like that. Like, oh, well, we're trying to give the victims what they deserve. We're trying to give them justice. That is not what this system is set up to do. And that's why it fails so miserably at doing it, right? It is very good at holding people accountable when they break the criminal statutory laws, period, right? And so to be able to see restorative justice as a way in which to actually honor what we have been telling people we're doing for them, right? Which is trying to get them some access to justice or to answers or to whatever it is that we keep telling them that we're doing when we're actually not doing.
Thank you so much for adding that. And I want to bring you in, Seema, as well, because your office has also used restorative justice in cases that are often the opposite of low-hanging fruit, for lack of a better term. And you've used restorative justice circles, I think, over more than 300 times in assaults, stabbings, robberies, carjacking cases. Can you talk specifically about using these approaches in juvenile cases? And some of the advantages that you see as a result. And I'm particularly interested as well, if we could talk about recidivism a little bit and the impact of using restorative approaches on recidivism.
Sure. Well, we are doing this randomized controlled trial, but these evaluations take a long time, especially because you have to follow all of the people afterwards to see if they've recidivated for a year or 2 years. And so we still are awaiting the kind of rigorous findings from this research. We have done some, kind of in-house analysis of our data that shows reduced recidivism among the young people who complete the restorative justice process compared to kind of a similar group of young people. But the rigor of that analysis is far less because it's not randomized. But the most rigorous evaluation I have found to date is one that comes, it's like a 9-year study studying over, I think, 2,000 different cases. And these cases occurred in sites across Australia and the United Kingdom, UK. And I think that there were, if I remember correctly, 7 different sites. And in each one of these sites, they used a randomized controlled trial to see who would be offered restorative justice and who wouldn't as an alternative to traditional court processing. And in some of the sites, the location would use restorative justice for juvenile cases, and some for adult cases, and in some for both. And in some sites, they would use restorative justice only for property and low-level crime, and some for only serious and violent crime, and some for both. And so there was like a wide range of the use of restorative justice. And there were a couple of findings that really stood out to me from this really long-term, super rigorous study, which showed overall recidivism was less for across all of the sites for people who completed the who went through restorative justice process compared to those who went through the traditional process. But one thing that they found was that the recidivism reduction was greater for people who had committed serious crimes as opposed to non-serious, non-violent crimes. And another thing that they found was recidivism reductions were greater for adults than for juveniles, both of which I think are surprising. I believe that in one context, offering restorative justice for juvenile cases is a pathway that allows for more opportunity for innovation, in part because there is more political space when you talk about children than when you talk about adults. There's more kind of tolerance for kind of innovation or programming or rehabilitation, built into our statutes about juvenile crime in the juvenile court system than on the adult side, and also like kind of intuitively. On the other hand, I think that the value is, as the study shows, across the board. And the key value to me is that when you have a young person or an adult who is faced with the person who they harm, who has to talk directly to the person that they hurt, and they have to take responsibility and say exactly what they did, answer those questions that everyone has been talking about. What were you thinking? What were you going to do with my stuff? How dare you? What would you have done if I resisted? What would you have done if I didn't resist? Did you target me? Why did you pick me? These are all questions we hear again and again and again. And the research on trauma shows that when somebody has experienced a trauma, they need something in their brains to form a narrative to explain what had happened, even if it's not an excuse, right? Even if there's no reason that explains or justifies the behavior. You need a narrative and your questions answered in order to move that experience from being at the front of their brains in the trauma so that it's present and constantly a part of their days, to a part where they've processed it and can integrate it into their lives and move forward. So this is like a trauma response for people who've experienced victimization. But what's important from my mind in terms of recidivism is when you experience that, when you see and hear from somebody who's been so badly hurt about how badly they are hurt, it builds empathy and it builds consequential thinking, right? And, for a little while, I used to do these kind of quality control calls where I would talk to participants a few months after a restorative justice conference, and I got to talk to a bunch of young people. And I would always ask them, like, what did you remember from this experience? And they always talked about how badly the victim was hurt, about how they didn't realize how badly he was or she was hurt, and how bad they felt about it. That's the abiding thing that stays with them, because that's how we build empathy. So there are two things that are happening. One is they're taking responsibility for their crime. And what the research shows about behavior change is that the threshold thing that needs to happen to change your behavior is you need to take responsibility for what you did. And then the second thing you're doing is building empathy and consequential thinking. And that's why we see people changing behavior. And that's why we see recidivism going down when you use restorative justice.
That's amazing, Seema. And I wanted to ask you also about cases that are not successful, that your office has experienced, and why those cases didn't succeed, and what lessons prosecutors can kind of take from those experiences, and as well as what is the process. So what happens if someone does not succeed through that process? What happens next in the case?
Well, when somebody doesn't succeed with the process, we hand the case back to the prosecutor for traditional prosecution. And so, we are able to say to the victim of the crime at the beginning and throughout the process, if you change your mind, if you don't want to do this anymore, the case just goes, you don't lose anything, right? It goes back to the traditional process. The prosecutor will move forward with traditional prosecution. And we do have sometimes when young people fail, and there are a couple different ways to fail. One is to not participate and not, go through the preparation needed, to work with, like DA DeBerry said, that, you're working with the restorative justice facilitators in advance before you would ever meet with the person who was harmed. So you've got to meet with them pretty frequently. Our facilitators meet with the young people at least, once a week for several weeks before they would ever put them together with the victim of the crime. They're also meeting on the other side with the survivor or the victim. But most people who agree to do it participate and come to the meeting and participate in the meeting. Another way that a case would not be successful is if the group doesn't come to an agreement. And that sometimes happens where there's kind of a blow up, right? And it's not very common. It's like very, very rare, but there are some times when we have a parent of a young person or a family member or the victim who just gets very upset and kind of walks out and says, I'm done. And that happens. And then the other way that somebody can fail is where they don't fulfill the terms of their agreement. So DA DeBerry talked about a repair agreement. We call them, restorative justice agreements. And so it's a consensus document that's come to by all of the parties about what needs to happen to make things right so that they won't happen again. And everyone agrees to them. And then we monitor and track compliance with that. And, sometimes our young people don't comply with all of it. And if that's the case, then they've, in most of our cases, because we take almost exclusively serious violent crime, the young person has entered a plea agreement that's held in abeyance pending sentencing. And so in that period of time where we're doing restorative justice, we're not only monitoring compliance with the agreement and restorative justice, but if they pick up another offense or those kind of things, then their conviction would lodge at that point.
I know we have a lot of questions in the chat, and I promise we're going to get to them in just a moment. So I'm going to cut through some of my other questions I wanted to ask. But real quickly, before we get to some of those questions, I wanted to ask about the collaboration involved in restorative justice approaches. And I'll ask this to all of you in different iterations. But DA DeBerry, let me start with you, because there are so many moving parts in getting, as we heard a little bit from the example you shared, in getting restorative justice through the court system. How do you get everyone on the same page, including a judge, to agree to the terms that come about as a result of that process?
Well, you just have to know everybody. You have to have been working together for a long time. Even if you're not, and when I say working together for a long time, I mean working through the case itself or through these processes together for a long time. There has to, people have to trust each other. And, we're human beings. We have a lot of cognitive biases. And one of the biggest one that we have is fear. And we just have to kind of constantly overcome that with each other and move at the speed in which move at the speed of our slowest trusting person, I guess. And that's sometimes the judge. But we've now, had judges who have participated in these cases in all sorts of ways and have come to, or have started to understand and trust the process. Some will never participate in it. Judge Ofalu, who was the judge in the Fields case, felt very strongly about it, and will probably, long after I'm not DA or whatever, he will probably continue to do these cases because now he's developed a level of comfort and a level of understanding and control over the processes. So you just got to trust each other and keep building that over and over and over and over again.
Thank you. Seema, I wanted to bring you in. You were, as I mentioned in your bio, you had started your career as a trial lawyer with the DC Public Defender Service. What is the role of defense counsel, and what can they expect from prosecutors during a restorative justice approach? And what advice do you have for prosecutors on this call to work more effectively with local defense attorneys in restorative justice cases?
I was surprised to find when I came to work at the prosecutor's office in the same jurisdiction where I was a public defender for many years and knew lots of people who were still at the public defender service, that the resistance from the defense bar was as great, if not greater, than the resistance from the prosecutors. Right. And, it took some time for me to remember and to understand, and a lot of conversations, how scary restorative justice is for a defense attorney. Because what you're trying to do as defense attorney is protect your client at all costs. And that means having a lot of control over everything, including how to explain what's going to happen to somebody. And with restorative justice, you have very little finality. You can't be in the circle with your client. You can't tell them what they're going to have to do, because that will be determined in the circle with the victim, right? Who you don't really know and probably don't trust, and you don't trust the prosecutor and you don't trust the system. And so there's a lot that defense attorneys really have to get over in order to be willing to advise their clients to take restorative justice as an option. And so what we needed to do, and what I think prosecutors have to do, is aggressively incentivize doing restorative justice. And you're doing that for many reasons, because as prosecutors, as DA DeBerry really well said, prosecutors are ministers of justice. And what we're looking for is community safety. And if we know we're going to get better recidivism and crime and safety outcomes with restorative justice over traditional prosecution, then we have to be willing to do what it takes to use restorative justice. If we know that victims of crime and communities are going to get more from that process, then we have to incentivize it, because we believe that that's going to be better for the community. And so what that means is that prosecutors have to take a deep breath and give a better plea than they would ever consider, and use restorative justice with that plea offer. And what our prosecutors do is they offer two plea offers, a traditional plea and then one with restorative justice. And the restorative justice plea is significantly better. And what that does is it puts the defense attorney in a position where they really have to advise their clients to consider restorative justice, even though it goes against every fiber of their being. And what we also find is with young people, when you tell them you might have to have electronic monitoring, you might have to be on probation, you may even have to be locked up in the facility. They're scared of that. But if you tell them that you have to sit down with the person you hurt, tell them exactly what you did, and hear from them about how badly it hurt them, apologize, and do whatever they say you need to do, they're way more scared, honestly, of doing that. It is so scary to them. They're terrified. Our kids freak out before every restorative justice conference. And it's because it's really, really hard and really scary. But change is hard. Behavior change is hard. Facing, what you've done is hard. And so while in a pure restorative justice model, which is one that we deviate from by putting it in our prosecutor's office, but in a pure model, this is a voluntary process on all sides. But we highly incentivize restorative justice for, in our case, defendants and respondents, because that's what we think is best for the community. And then we leave it to our facilitators to speak with the defendant or respondent to gauge if they are truly able to take authentic responsibility. And then they do an assessment. So even if a young person or a defendant were to say, yeah, I'll do that, the facilitator may say, no, this person's not well suited for this process, and we'll say no to the case. So yeah, that's a little bit of our relationship. Yeah, go ahead.
Oh, no, I was just going to wholeheartedly agree with you about when you have to take accountability. I also have in a previous life been a defense attorney, and there are a lot of people who would rather do the time than have to sit across from somebody and take accountability. You don't even have to do a crime to know that. A lot of us would rather go through the self-checkout line than talk to the cashier. So just, that kind of just level of deep human interaction, most of us are very scared of doing.
I want to turn to the questions, but first I want to bring in Professor Ackerman real quick to just ask you, how can prosecutors locate groups that engage in restorative justice? And if there's not a lot of established restorative justice resources in a specific community, what options might a prosecutor have?
First, I'll go back to what DA DeBerry said. Restorative justice is about relationships. It's all about knowing people. And you might not know that there are restorative justice facilitators or organizations operating in your area, but there probably are. They might not just use the name restorative justice in their title. So look harder because they probably do exist. And if they don't exist, there are statewide restorative justice coalitions. There are national organizations that are doing restorative justice that offer technical assistance. And so you can look at the state level. You can also look at the national level to start building those relationships to help create restorative justice options in your offices.
Okay, thank you all for your patience. I know there's so many questions, so I'm going to get through as many as we can. The first question I want to ask, which I think makes sense to ask Seema, but feel free to jump in if anyone else wants to, where an accused stands to receive a benefit from having engaged in an RJ process, for example, in a criminal case or school disciplinary process, do you find that the promise of an incentive corrupts the authenticity of the process?
I don't believe it does. We have now done many, many, many cases. I've myself facilitated, many, many cases. I've sat in and observed countless cases. And, these are very emotional and powerful experiences where people, in the end, more often than not, somebody's crying, they're hugging at the end, people stay in contact with each other after they've been harmed by each other. They're very powerful experiences. And I think that there is a level of, coercion when you incentivize restorative justice, for sure, that exists. On the other hand, when it comes to a moment when you have to, a moment or 2 hours or 3 hours where you have to really, engage, as DA DeBerry said, engage with the other person as a human being. And when you've committed a crime, it's not only just a scary engagement, it's an engagement where you feel really shameful about what you've done and really guilty. And it's very scary. There's lots of anxiety there because they know that everyone looks at them and thinks, you're a bad guy. But what's amazing about the process is there is also this pathway to humanization and then redemption. So because you spend 2 hours talking, and because there are all these parts of this restorative justice conference built in to ask questions about your past and your feelings and this and that, what happens is you start to see each other as human beings, all of you, and this circle of people, the people who are directly impacted and their supporters and the facilitators, you become this little microcosm of a community. And what happens at the end with this agreement is you are able to see how somebody is like, I messed up. I did something terrible. I hurt somebody who I'm looking at right now and their family members. But there is something I can do as a pathway to redemption to show that I'm really sorry and to show that I'm better than that and I am a good person. And that's a key part of this process. And there's something so deeply human about that you can't really fake that. And so even if you go in with like more of a, an incentive and you're doing it because you want to, get a better outcome from your case, it transforms into something way more powerful and human. Sometimes that's hard to get across unless you've seen one, but it almost always happens.
Thank you. This is a question for Dia DeBerry. How does your office fund restorative justice work?
We don't. We have a community partner that does the facilitation of it, that they're a 501c3 nonprofit that raises money however they raise money. I'm not exactly sure how they do it, but they do. And I'll just amend that a little bit to say that we do have a little bit of money to do mediation. Probably the place that we use this the most is in our traffic fatalities practice. And we do have we have the judge who coordinates the kind of restorative process for that he's a retired judge, and he's been designated by the North Carolina Supreme Court as a certified mediator. And so he can charge the court system for his time. But in the other processes, outside of that, we use a nonprofit. So you don't need money to do it. You just need intention to do it.
I have another question for you, DA. How do you handle the issue of the potential for statements made during the restorative justice process to be used in a civil proceeding brought by a survivor and wanting to have an accused on board with restorative justice?
Everybody signs an agreement not to do that beforehand. So any statement against interest that happens, can't be used. And also, as the prosecutors, we do not participate. So we're not hearing anything that's being said. Nobody's reporting anything back to us. So we want everything to be these confidentiality agreements are super duper important if you're going to do this process. And we've got examples, I'm sure, like Professor Ackerman says, she has examples, and there are other organizations across the country that have examples of confidentiality agreements. And we have yet to see anybody violate any of them.
That's great to hear. Professor Ackerman, in a sexual misconduct case where two people have different experiences of the same event, would you initiate an RJ process if the accused is willing to acknowledge harm, but doesn't agree with the entirety, or maybe doesn't admit to the entirety of the complainant's factual description?
Yes, because we talk about, so oftentimes people engage in harm and don't recognize that their behavior was harmful. And because of the shame that they have around the harm that they've committed, cannot name the extent of it. And sometimes people have two very different accounts of what happened. And so we dialogue about that. And that can be very healing for both parties. So yes, I would absolutely take that case. Yes.
Fantastic. And I accidentally pressed answer live to a question that asked if this is recorded. It is recorded. It will be posted, and we will send her in any additional links. I know there's a lot of requests for links in the chat. I wanted to ask this question to Seema. In Vermont, young adults for some charges are able to be prosecuted through our family court division to preserve our young people's future. I would like to see more opportunities for restorative justice rather than probation. There's an opportunity to heal harms, and in my community, we don't have buy-in from the prosecutor's office, where justice seems to lack the search for the truth, but looking to plead out cases. Our plea rate is 99%, which I don't know we see as an admission of guilt, but the option you choose to reduce the impact of the charge in the defendant's future. How would you help change ADA's views from pleas to restorative practices?
That's tough. A culture change in a prosecutor's office is really, really, I think, challenging, but not impossible. I think DA DeBerry is kind of the premier example of how leadership from the top is critical, and real passion and vision from the elected about the program is probably one of the most important things that you can have to support a program. My understanding is that Vermont actually has, as a state, has a long history of restorative justice in different contexts. I know that Vermont has, I think they're called COSAs, Circles of Accountability and Support, and they use those in the parole context, and that there is some kind of restorative justice landscape. What we found to be really powerful in building buy-in from prosecutors in our office was that when we were having a restorative justice conference, we would invite one by one, with permission of all of the participants, a prosecutor to kind of take off their prosecutor hat. We would firewall them from the case and sit in and just observe a restorative justice conference. And what we would find, as scary as that was, I was terrified before. The first time we did it, I picked the prosecutor in our office I liked the best. I would only invite the ones I was friends with. And then what we would find is that that prosecutor, after experiencing a restorative justice process, would send us more cases and more serious cases after that experience. And so we then kind of made a policy that we would do that with all of the prosecutors at least once they were hired, to allow them to observe a restorative justice conference. And that was really the thing that I think moved the culture the most in our office. And so because Vermont might have capacity or nonprofits or groups who are kind of already versed in the principles of restorative justice, I would encourage you to try and bring folks who are practitioners in to meet with, ideally, people at the DA's office, and have them talk about the power of the work.
Thank you.
I want to say that this work also goes both ways. Of course, this forum is to inform prosecutors about it and get prosecutors to use it more often. But I also find that on the RJ side, there are a lot of people who just don't know what we do. Most people, honestly, don't know how the criminal legal system works. And they see how challenging it is to do this work. And what a limb a prosecutor who has referred a case is stepping out on. And so they're learning too. It's not just going one way. It's not just the prosecutor has to give up everything to be doing this. Everybody's giving up something, even if that's their belief that the criminal legal system is evil at its root and must be rooted out, or whatever. Everybody's giving up a little bit of something of their core belief to be here at the table.
Yeah, I'm going to stick with you for another question. Where did the types of restorative justice strategies being discussed here fit with other diversionary strategies, such as pretrial intervention, substance addiction courts, etc.? Also, if the perpetrator refuses to take accountability, but incarceration isn't the right answer either, how could RJ/trauma-informed diversionary practices help rectify the harm?
Oh, that's a big question. So I often say that as a prosecutor, I'm a hammer and everything to me looks like a nail. And what you want to do is give me more tools in my toolbox. And the more tools that I have, the more situations I can address. There are some things for which incarceration is the only option that we have. And then there's some things for which complete dismissal or complete diversion from court is the only option that we have. Most of what we're doing is somewhere in between that. And so as an elected leader, I feel like it's my responsibility to give my prosecutors as many tools in their toolbox and as many ways to use their discretion. Because we hadn't talked a lot about this today, but the one thing that a prosecutor has that almost nobody else in this system has is discretion. And it is a muscle that you have to exercise to get better at using. And you have to be willing to use it in as many different ways as possible. And so, yes, we offer diversions, we offer substance abuse courts. We also recognize that, there are a lot of cases that we deal with that are victimless, right? So restorative justice is not an option. Most of what we do doesn't involve victims, right? So you're still going to be prosecuting cases in kind of a more traditional manner. You're still going to use more traditional diversionary processes or diversion courts or probation or all kind of other things. But you got to have, this is just one of many tools that we hope makes this system more fair and just.
The next question is for Professor Ackerman. How do you receive referrals? Who sends both parties to you?
So usually referrals come directly from survivors who reach out directly saying that they want a process. And then after, an initial conversation with the survivor, we will reach out to the person who perpetrated the harm and ask if they are interested in participating. A lot of the cases that I am seeing right now are actually institutional cases. So they're not individual survivor cases. They are large religious denominations, churches, synagogues, asking for help to respond appropriately for their lack of responding appropriately in the first place to disclosures of harm. And so, we are working with these large institutions to help them take accountability for the secondary harm that they've caused. And then we are, when these institutions reach out, we are having conversations with survivors. Is this something that you want? Because if this isn't something that you want, we're not going to engage in this process. But more often than not, survivors are saying, yes, we want to engage institutions too. And so we are reaching survivors that way. So mostly the bulk of my time right now is spent on these institutional cases. Some of them are very public, some of them are not. But we're reaching survivors in that way.
Another question about survivors for you, Professor, that just came in. You mentioned that the approach is survivor-centered. Does that mean that the survivor singularly decides whether a restorative justice process has been successful and or that the accused has met expectations? And others can weigh in on this too.
So survivor-centered means that we start by asking, what are your needs, wants, and goals? And how do we create a process that helps to meet those needs, wants, and goals? But again, the role of the facilitator is to oversee the process and to ensure that no additional harm is caused. So if a survivor is saying, I want $1 million, that's not going to happen in a restorative justice process, right? So we have to set the limits of the process up front, right? What can we achieve in a process like this? What is reasonable? What can you expect from a process like this? So we can push, with the person who's perpetrated harm, we can make them uncomfortable with accountability measures, but we are not going to do something that causes harm to them. So in that sense, it really isn't up to the survivor to decide. It's up to the collective to decide. And that's why, all three of us have sort of been talking about these agreements that we come to, and a case, may not be successful if we don't come to an agreement among the parties that are involved in a process. So survivor-driven, survivor-centered, yes, we are thinking about the needs of the survivor, but they don't have the sole say in the process because the process is about everybody.
Question for Seema. what are specific tools or classes that you provide to the person who perpetrated the harm to initiate consequential thinking?
Well, once we started moving into taking serious violent crime, and given our experience working with young people doing restorative justice for the few years that we had been doing it previous to that point, um, we decided that we wanted to help young people in serious cases with building the kind of muscle and practicing the process of empathy and consequential thinking and um, those kind of things. So what we do is for young people who are in our program, in addition to doing the restorative justice process, we also have them participate in 10 weeks of group cognitive behavioral therapy with an outside community-based provider. And so with that, what we're hoping is that they are getting practice at making better decisions and at taking time before they make decisions. 8 seconds apparently is what young people need in order to stop and think and to make a better decision, not react out of emotions or possibly trauma that they've experienced in their own lives. And so that's our effort to try and really cement some of the principles that we're hoping that they will get from restorative justice.
We have a couple of questions I'm going to consolidate about victims' families. One question was, are there any resources for the victim's family for preparation with opening communication with the defendant? And the other question was, please give us your thoughts in our responsibility in informing families of getting representation for their family, since the state will not.
This for me, Rachel?
Sure, anyone who wants to answer, sorry.
Okay. I hope other people can chime in. I don't know of any resources, so we don't necessarily provide materials or reading to families or families of people who've been harmed or the individuals themselves. Our facilitators are just really well trained at working with people who've experienced trauma. And so they're really careful with that. And they help both sides prepare for the meeting. And sometimes what that means is practicing saying what you really want to say. Because when there's a lot of anxiety, sometimes, folks get choked up or, are, shy or anxious and unable to say what they really wanted to say. So what's really important is that our facilitators are able to build deep trust with all parties and then be able to really talk them through what they're feeling and what they need and what they expect to feel when they are confronted with the person who hurt them and how they're going to react to that and what they think is going to happen, and then practicing if they're worried. So that's what they do. I think the second part of your question, I'm not sure that I have an answer to, so maybe somebody else can chime in.
What was the second part?
The second part was about informing families about getting representation if they need it, since the state won't provide.
Yeah, I don't know what that means.
Okay.
I will just say that I'm a prosecutor. I am not a restorative justice facilitator. And so what our prosecutors are trained to do is look for the green flags. I would encourage every prosecutor to read Until We Reckon by Danielle Sered, because there is a way that as a prosecutor, you think about victims that is not true. I'm just going to be flat out honest with you, right? You have a view of victims that comes from a system that has been punitive over the centuries and is top down and enforceable. And I guarantee you, and I know some of you are sitting back and pushing back on this, and you're like, I know what my victims want. You do not. So read Until We Reckon and open yourself up to learning that sometimes you're not seeing what you think you're seeing, right? They're coming to you a certain way, but at home or when they talk about it, they're feeling another way. So saying that to say, our prosecutors are trained to, when they start to see these green flags, to do what we call a warm handoff. And the warm handoff is to somebody who knows what they're doing and who can prepare these families and talk to them about what the process will look like and how, and at any point, families can back out. They can say, no, we don't think this works for us, or yes, we want to keep going forward. I don't know how that works because I'm not an RJ facilitator, right? So we let the people who do what they're good at do what they're good at. And as far as representing the victims, we do not represent victims. I don't know how many different ways to say that as a prosecutor. I represent the state of North Carolina. I represent the people of North Carolina. I am enforcing the criminal statutes of North Carolina. I'm worried about community safety, public safety, and accountability when people do that. I don't represent families. I don't think that the families need representation in that particular way. But I think if they are dealing with one of our community-based partners who does RJ, they are getting a lot of representation that they otherwise would not get in this process. So.
We have so many questions, and I'm sorry we can't take them all. I want to give everyone an opportunity to say one last very brief final word to the folks on the call. I'll start with you, Professor Ackerman. I know you have to hop off.
I did it again. I just wanted to say thank you for the opportunity to be on this call. I really appreciate the opportunity to be with people who I really, really respect in this field. And, as DA DeBerry said, give this a try, read that book, read Until We Reckon, listen to victims. Restorative justice works if you give it the opportunity to. Thank you.
Seema, any final thoughts for the prosecutors on our call and everyone else on our call?
Thank you. I actually do, and it's not going to be some like soaring final statement. I just wanted to add to something that other people have been talking about. DA DeBerry introduced green flags, and we've all talked about victims of crime who have questions. I just want to throw out a couple of things that I see as the green flags also, that as prosecutors, I think prosecutors on the call, I think that they will resonate with you because they definitely resonate with prosecutors I've met. And one is situations where you have a victim of a crime who is actually looking for an alternative to the kind of punitive response that the justice system offers. And they'll say things like, look, I don't want to ruin this person's life, or I realize the system is racist or brutal, and I don't really want to be a part of that, but something really should happen. Those are cases that are low-hanging fruit for restorative justice. As others have mentioned, times when victims have lots of questions that the process does not allow any answer for, those are green flags. And the final example of a green flag that I would throw out there is situations where people know each other, because you can prosecute one person who's gotten into conflict with another person fully, and then at the end of that prosecution, the underlying issue and conflict will not be addressed, and there will be more violence or conflict or fear. And with restorative justice, you can get at the underlying issue, solve it, and create safety for everyone involved.
DA DeBerry, I'm going to give you the last word and just reassure everyone in the chat. This is recorded. It will be posted. We'll upload this on our website so you can rewatch it as many times as you need, and we'll be happy to follow up. And I know that there's so much interest in this, and we're really excited about that. So DA DeBerry, take it away.
I don't know if I can say anything better than what Seema just said. I want to thank y'all for giving us this platform to do this, and I would encourage prosecutors to really learn more about it. If you are the elected, teach yourself, get some, there are lots of ways to get out there and find out what's going on and teach yourself and bring it back. If you're a line prosecutor, learn about it. Again, your discretion is the one magical tool that you have, and the more tools that you have, the better a prosecutor you'll be.
Well, we could clearly talk all day. There's so much engagement in this, and we're so grateful to all of our panelists for joining us and sharing your wisdom and experiences. As I mentioned, we will be posting this on our website as soon as we can get it uploaded, and we'll send it out to our listserv as well. So make sure you subscribe at prosecution.org if you aren't already subscribed, so you can make sure to be here for all of our future events. I really want to thank you all. This was a fascinating and really informative and helpful discussion. So thank you all for joining, and we will see you all next time. Thank you.